What should I do if the driver who hit me was intoxicated? Does that affect my injury claim? Yes, an intoxicated driver can still be held financially responsible under the same basic negligence rules. And intoxication can also support a claim for punitive damages in the right case. But it does not replace the need to prove fault, that the crash caused your injuries, and what your losses are. So documentation still matters a lot. Right away, preserve the basics while they are fresh. Photos if you have them, witness names and contact information, and a short written timeline of what you remember. Keep all medical paperwork from the emergency room and imaging, and keep a simple log of symptoms and missed work. Next, confirm there is a crash report and that the impaired driving issue is being handled on the criminal side, because the criminal file can create useful evidence like officer observations and testing. Keep your insurance communications organized. Save letters and emails, write down call dates and times, and avoid giving detailed narratives over and over to different people, because inconsistencies can hurt your claim. As the case develops, you will usually need medical records and bills, proof of lost income, and evidence tying your injuries to the crash. And if the facts support it, punitive damages may be evaluated in addition to compensation for medical bills, lost income, and pain and suffering. Be aware that even with an impaired driver, the insurance company may still argue you contributed to the crash, and in some places, that can be a complete defense, so careful fact development is important. Finally, do not let claim delays push you past the filing deadline. Most injury lawsuits must be filed within 3 years, so it can help to speak with a personal injury attorney promptly to track deadlines, gather evidence, and take over communications.